Hi, everyone. We're going to get started with our last session of the day, which is on DAO Legal Structure. Our session moderator will be Stuart Levy, a partner at Skadden, who co-heads the firm's Intellectual Property and Technology Group. Stuart also coordinates Skadden's blockchain outsourcing and privacy practices. Stuart, over to you. Nice to see you all.
Great. Nice to see everybody, and thanks for joining our panel today. I'm going to let our panelists introduce themselves in just a moment. Just by way of background, what we thought would be important when the symposium was being planned was to spend some time, and this is what this session is going to deal with, on the legal issues surrounding DAOs. It's become particularly important, and we've heard a lot about DAOs already today, and we'll hear more in the coming days. DAOs historically have often existed sort of reactively within this space. In other words, a lot of protocols assume the existence of a DAO or as part of their governance, the idea of some decentralized governance structure. What we have seen more so, I'd say, over the last year to 18 months is what I've sort of seen as the active creation of DAOs. In other words, people creating DAOs for the sake of the DAO, for that being a decentralized form of governance, and then for embarking on a project with that structure. So the question as a lawyer is, well, then what is a DAO as a legal matter? Sometimes when you talk to to people in this space, they say, well, a DAO is a DAO, as if it had, by just that name alone, its own legal structure. And the reality is that it's much more complicated than that. Just as a practical matter, in the United States and in many countries of the world, we live in a rule-based society, a judicial-based society, where the rights, benefits, obligations, liability that you face depends on the strength of the court system and how courts interpret what you are doing and what framework they put it under. In this space, you'll hear a lot often about, well, none of that matters because the code is the law. But the practical reality is that that's not true for two reasons. One is that code does not solve for every legal issue that might arise, and you could very well end up in a court system and then faced with the question of, well, what exactly is the DAO as a legal matter? And also, just as DAOs have found as they go out into the world and look to contract with third parties often want to understand the counterparty that they're dealing with and what sort of legal structure does that entail. And the problem that we have today, or the issue that we have today that we'll spend some time over the next hour talking about, is that our laws of organization, of entity organization within the United States and in most countries in the world are based on a centralization focus. It assumes some degree of centralization, which of course within the Web3 space and with DAOs is for sure not always the case. So it should be for an interesting and hopefully very informative discussion. With that, let me turn it over to each of the panelists and I'll let them introduce themselves and then we'll dive right in. Matt, why don't you go first? You're, at least on my screen, you're first up, so we'll start with you.
Sounds good. Thank you, Stuart. My name is Matt Kaufman. I live in Cheyenne, Wyoming. I'm a partner with the law firm of Hathaway and Coons. I've practiced for about 17 years. I used to be a corporate tech startup attorney. These days, almost exclusively focusing on crypto. I was appointed by two different governors, or have been appointed by two different governors in Wyoming to the standing legislative blockchain committee here in Wyoming. That's the committee that produces most of, actually all of the legislation that Wyoming has passed. So I've gotten an opportunity to work on pretty much every piece of legislation that Wyoming's been involved with. And then I have to plug quickly my side hustle, which is I'm a partner in a cryptocurrency hedge fund that we were globally ranked 6th in the world last year by Barclays, based out of Denver, Colorado. That's it.
Hey, Jackie, why don't you go up next?
Sure. So my name is Jacqueline Redebaugh. I am an attorney with Jason Weiner PC. We're based in Colorado. We have attorneys in several different other states. I typically provide legal services to startup cooperatives and other models of shared ownership and shared governance models, and have been working with DAOs for the past year or so, and have actually adopted the cooperative model for a good dozen of those, and have been working with a variety of DAOs in the sector that are mostly interested in adopting the cooperative model. Happy to be here.
I'm glad to have you. Lucy?
Hi everyone, I'm Lucy Frew. I'm a partner at Walker's Law Firm, which is an international law firm. I'm based in the Cayman Islands, and we have offices not only in Cayman, but also in the BVI, Bermuda, Jersey, Guernsey, Ireland, London, Dubai, Singapore, and Hong Kong. But it just so happens that for today's topic, the Cayman Islands is the jurisdiction where we are seeing most activity for DAOs.
Great. And Miles?
Yep. Hi, everyone. I'm Miles Jennings. I'm general counsel of the A16Z crypto group. I've been here for about 9 months. Previously, I was a partner at Latham & Watkins working in their emerging companies practice. Have worked with a lot of companies in the space, in DeFi sector, including Uniswap and Aave, and then at A16Z, I've been kind of just working with our whole portfolio on kind of navigating the regulatory challenges in the space.
Great. All right. Thanks, everybody. All right. So let's dive in. So one of the things that you quickly come to realize when you're working in this space, particularly with DAOs, is that there's no single type of DAO. And I don't just mean that from a legal organizational point of view, but also in terms of what the DAO is meant to do and what its function is. And I think that's a good grounding because it'll influence some of the discussions we're going to have on legal constructs and different legal models that are out there. So Miles, you're up on the screen. Maybe if you could talk through some of the different models that you're seeing of, what does it mean that there's a DAO and what it might be doing?
Sure. I mean, I think that the kind of concept initially arose out of a lot of decentralized governance organizations that were set up around various blockchain network and smart contract protocols. So, for instance, Compound and Uniswap are two examples within the DeFi space. I think that the first instance of DAO was really the DAO that was set up as kind of a joint investment vehicle, back in, I think, 2017 or 18, but really, out of those, right, there's kind of been a morphing of various different types of DAOs that have really kind of popped up and made the analysis, I think, a little bit more complicated because it's hard to kind of find any legal structures that really fit, every single use case. So I think one of the ways that I conceptualize it, right, is that, for DAOs that are being set up to run what look like, they're real world analogs for the business. So such as like investment DAOs or collector DAOs, right? Or collectives, it's easiest place to start, right, is really looking to the legal structures that those kind of organizations would have in the real world, right? So for investment DAOs, right, you might look at limited partnerships and LLCs. And for collectives, you might look at the co-op structure, and then for protocol and network DAOs, right? I think that you really need to look at kind of what are the key features that you want your DAO to be able to have in order for it to kind of be able to operate in accordance with the kind of overall goals and operations that it has in mind.
Great. Jackie, how about you? What were some of different DAO purposes, let's say, that you've seen in your work?
Yeah, so we're seeing everything, right? So I think the previous panel talked quite a bit about DAOs as startups, and I think that's what I'm seeing. It's just Web3 native groups that are adopting any business purposes that any other startups, any other business entities can adopt. I'm seeing quite a bit of producer types of entities, so artists, DAOs, for instance, they're producing NFTs, they're producing digital assets that might be sold. A version of that can be a consumer type of entity as well, whereas there's a good digital good generally that is sold, and there's a bunch of stakeholders that are part of that entity as well that kind of look like the cooperative or REI type of entity that functions on a consumer basis. And we're seeing folks in the music industry quite quite strongly. We have a few of those clients, a good chunk of folks doing environmental work, so promoting environmental protection and other developments related to the environment. And then quite a bit of groups as well interested in tokenizing and adopting real estate investment models, but also sharing. I think the shared governance, shared ownership, and profit sharing are just things that we're seeing across it. And then the rest, as far as business purpose, can be, it can be anything.
Great. And Matt, anything you're seeing that we haven't covered already?
No, I think both of the prior speakers have covered it pretty well. The only two things I would add is we've seen a lot of DAOs surrounding like employee groups that are wanting to organize and sort of offload the employee group structures from entities. And the other one would be charitable purposes, where we've seen a real emergence of DAOs wanting to launch for charitable purposes as well. But no, I think otherwise same as what's been repeated.
Great. Okay, so a lot of different structures out there. Good jumping off point to now dig into. So what does that mean for the legal system, and what does that mean for lawyers? So let's start with sort of the basic concept or the basic situation, which is we get some group together and they call themselves a DAO. So as a legal matter, they've done nothing. They've just come together as a group. They've maybe created or got someone to write for them a smart contract, developed some sort of protocol that maybe has some sort of governance aspect to it. But as a legal matter, they've done nothing. Call it 20 people, 50 people, 500 people have gotten together and do this. What would that mean as a legal matter? So now there's some issue, and we can imagine a lot of different situations that that can come up. Lucy, let's start with starting outside the United States. So in the Caymans, if you have that group come together, they've done nothing formally. How would the legal system in the Caymans or the judicial system there view that? What box would it look to put that into?
Well, in the Cayman Islands, what we see as a law firm is really the DAOs that want to have a legal structure because they have had the realization that they won't be able to achieve what they want to do or have the protections that they need without having a legal structure in place. So, we can come on to talk later about what that structure, the legal structure, would look like. But the things that they've been facing are that without a legal structure, they may not be able to enter into an agreement with a third party, especially things like crypto exchanges, those that want to be able to buy and sell tokens on exchange, or they aren't able to protect their intellectual property as they would wish to, or that they aren't able to legally hold assets. The other issue that comes up is that regulators and in particular the Financial Action Task Force has focused on this. And they've said that where you have a decentralized structure that doesn't have a legalized structure, there is still a need for regulators to look to somebody to have responsibility for whatever activity the DAO is carrying out. So if they don't have a legal structure, then they will look to individuals, and that could be individuals such as developers, or they'll look to see who's receiving any income from the DAO in practice. Really, I suppose the reason that we see that a DAO without a legal structure is running into issues is the same reason that limited liability companies were invented, some hundreds of years back. It was to protect individuals so that they didn't have individual liability, and to have an entity instead which would have that liability instead at the level of the entity. So it would protect the individuals and allow the DAO to carry on its activities with legal protection and enable it to enter into contracts.
Got it. Great. That's very interesting. Let's circle back to the liability point, because I want to come back to that in a moment. Matt, how about in the US? Same fact pattern, a bunch of people get together, form what they call a DAO, but have otherwise not entered into any form of legal structure. How would US courts or the US legal system treat that group?
Well, I think depending on some nuances, generally they're going to be considered, common law partnerships, and that's one of the problems that we heard a lot of testimony from here in Wyoming from DAO groups when we were considering legislation was, we are worried about this limited liability protection that was just spoken about. We are worried about holding, common property or community wallets and ensuring that there's legal rights associated with that. And so I think that's kind of the default answer that everyone assumes at this point. I don't know if there's been many test cases, but probably common law partnership.
So Miles, or Matt, but maybe Miles, if you could drill down for a moment. So what does that mean for people listening in here? When we say something's a common law partnership, what does that mean in terms of liability? Maybe start with liability or ability to enter into agreements, things like that.
Well, I mean, if Matt's right, there is risk that it could be, deemed to be a partnership. And I think if that is the case, it's kind of a awful outcome for the DAO itself, because each member of that partnership would be liable for the partnership's debts, for its whatever liability accrues to it. So, all of a sudden you have a bunch of people that are all acting, and if you're the only one that is not anonymous, or if you're the one with the deepest pockets, that certainly does put a target on your back. It also means that members of that partnership could bind you to a legally binding agreement, and so as a result of that, it's pretty risky overall. I think that courts will generally be reluctant to apply partnership law to DAOs, particularly ones that are formed around kind of technology. So for instance, like the protocol and network DAOs that I was referring to, it's hard to imagine that a person that potentially buys a couple tokens on Coinbase could somehow then be liable for a technology's potential liabilities. But I think it remains to be seen whether how that's going to play out. Certainly there have been some causes of action brought to try and kind of bring partnership liability to DAOs, but there are some nuances there, and there is a very real case for why DAOs should be treated as unincorporated associations with limited liability protection rather than as partnerships.
Got it. So just to drill down on that, and so folks hearing appreciate that. So if there was an issue, if someone had a claim against the DAO, the group of people who are the DAO, and they elected to just sue one of the individuals, as you said, deepest pocket, the one they can easily dox and identify, would that, I guess in that case, the defendant be able to bring everybody else into the DAO, or not necessarily? Could they be held liable for the actions of everybody?
Yeah, I mean, I think that they could bring their partners, but for use of a better word, into the case, right? But what if they're not able to identify them, and what if they're not don't have any information on who they are? One of the things that DAOs allow, right, is this collective action by anonymous individuals in a trustless manner. But if for some reason, right, you're brought into a case and no one else is, and most DAOs don't have set up indemnity for DAO members. They don't have ways to kind of protect all of these protections that we have in the normal corporate world in the US, right, don't really work in the context of DAOs. And so absent having a real legal entity structure and putting these mechanisms in place, entity-less DAOs really do expose their members to a lot of risk.
Right. And one thing we see in our practice, sometimes DAOs who show up at our door have said is, well, don't worry, we're not going to be a partnership because we've said in whatever document we've exchanged, we're not a partnership. This group will not be construed as a partnership. So Matt, back to you, and then Lucy, curious for your views in the Caymans. I mean, can you, through drafting, just trump that basic principle? In other words, you don't form anything, but you just say, we're not a partnership. Does saying that have any meaning at all?
Well, not very much meaning, probably, depending on the jurisdiction that you're litigating in. I mean, I think the problem is, and to answer that question super directly, I mean, one of the underpinnings of being classified as a partnership is that, as Miles alluded to, everybody's got probably joint and several unlimited liability, right? And so can just a simple document put all of the liability on some, particular actor? Maybe. Does that take partial steps to forming you as some other entity type? Maybe, and there have been instances of that, but it's usually deemed effective, because you don't uphold the proper formalities of whatever that entity requires. So I think that's and it's certainly one of the things, again, not to repeat it, but that we heard from a lot of developer groups here in Wyoming when we were doing the DAO legislation was there's no clean way to do this. And yeah, writing a little bit of code contract doesn't necessarily clean that up and give us a clean entity characterization.
Sure. And Lucy, how about in the Caymans? I know you started to touch on liability. Would it be the same concept that if I was a plaintiff, I could just pick a member of the DAO, deepest pocket, easily identifiable, and go after them and try to extract liability from them? And also the same questions to whether you could sort of word your way around being a partnership, or it's how you'd be construed. You can't just say you're not and wave a wand and then not be one.
Yeah, no, really the same answer I think applies. A document might be taken into account, but it's certainly not going to be the solution. Courts and regulators will look at substance over documentation to see what's happening in practice. And as before, people really come to the Cayman Islands because they do want to set up a legal structure. So we don't really have experience of DAOs that are not doing that.
Great. Okay. So let's jump into what some of those legal structures are. And Matt, I just feel Wyoming has earned the first seat at the table because of the great work that I know you've been a part of and that Wyoming has done in trying to bring some more formal legal structure to DAOs. So if you could spend a few minutes talking about what Wyoming has done, the origin story of how we got to now and what that law looks like, I think that'd be great.
Yeah, so I think the quick explanation is, obviously most people know Wyoming's been working on legislative clarity at a state level for a number of years now surrounding digital assets. And that really started with, and I think it's important for people to understand that the Wyoming DAO LLC works, at least in my view, in part because of some of the definitional structures that Wyoming put in place surrounding digital assets and defining them. We define digital assets in 3 different ways in Wyoming, and there's property rights associated with those. So we took that one step further, and again, there was a huge outcry of people wanting this limited liability protection. Wyoming being the birthplace of the LLC, it seemed like a natural fit to have this be a subtype of LLC. So the general thinking was, let's create a member managed as opposed to a manager managed LLC, designate it with certain default rules and structures that are supplemented by the Act, and work to build around some member rights and definitional frameworks that coincide and work with our definitional structure surrounding digital assets. And so that's what we did. And people ask me all the time, I'd be remiss if I didn't say this, because I was one of the co-authors of the DAO bill, myself and Aaron Wright from New York. And did we get it 100% right? Of course not. No, we didn't. Anybody that's ever participated in the legislative process knows it's really hard to get it right on the first time through, and there's a lot of compromises. We did just do some amendments, but what we've seen, I think, has been pretty remarkable. And one of the observations I would make of that is just we've seen a lot of people in the DAO community come forward, not so much with this attitude of this is going to be bulletproof, right? This is going to be tried and tested, and I can 100% rely on this entity structure. It's more a legal framework to experiment within, knowing that you've got a traditional LLC framework to fall back on if there's shortcomings and shortfalls. And so I think to date we have a little over 300 DAO LLCs have been formed here in Wyoming, all utilizing this structure. And yeah, that's really why I'll leave it at that without going into some of the nuances of the statute and some of the default rules. But I think what Wyoming was really trying to solve was to create an alternative entity that has enough flexibility, but yet has default rules. Understanding that you can do DAOs in probably almost any state's LLC framework, if it's flexible enough. But we really focused on those default rules and understanding that there's an underpinning to this technology that has to have a backstop, like all corporate legal structures do. And so that's where the focus was.
So Matt, appreciate not wanting to go into too much detail, but maybe go just one level down. Explain to folks what does it mean to marry a DAO to an LLC? What is that, sort of what does that look like? Because it might sound to people that that's two constructs that kind of can't fit together, but you guys have succeeded in doing that. So maybe if you just spend a little bit just explaining how that works.
Yeah, so as I mentioned, what we did was, because Wyoming has legislatively defined digital assets in these three different buckets, what an LLC and specifically what a DAO LLC can do is designate what type of digital asset its membership interests are going to be. So that's one of the first features of it. Secondly, we do have some, for lack of a better term, filing transparency requirements for these DAOs, with the idea being that we understand that people want to, not necessarily come forward with their identity. A lot of people like to participate in DAOs in a pseudonymous way or an anonymous way, but there still has to be some level of surface interaction, right? There has to be a touch point for these DAOs to have meaningful access to the legal system, for contracts, for bank accounts, or whatever interface that they're needing. So we really focused on a lot of the default rules surrounding member entry and exit into the DAO. Things like governance, voting and control, liquidation of DAOs, all those major problems that corporate lawyers address, right, when they're helping companies form and thinking through all of the exit barriers that they're going to face and all of the problems that the members are going to face when they're dividing up. And again, that's kind of where we focused. Again, it's member managed. It's not technology agnostic. That's one of the criticisms that Wyoming has seen, is that it is focused on blockchain technology. That was for a reason, though, because again, so much of our digital asset framework is based around blockchain and token definitional structures. But I don't know if you want me to go into more detail, but that's pretty much the structure.
But just to touch on maybe one last point, because we talked about liability. So from a liability perspective, if there was some issue, who's liable in a Wyoming DAO LLC?
Well, assuming that the court upholds, right, the LLC structure, the entity should provide limited liability protection. So in a member managed LLC, the members are not individually liable for the debts and obligations of the LLC. And so in this context, the DAO can designate managing entities or code or protocols or whatever the case may be for purposes of carrying out executable actions. So presumably there is liability protection.
Got it. Great. Jackie, let's switch to you and talk about sort of a different approach to DAO governance structures, and that's cooperative laws and the developments you're seeing and have been involved with in that space.
So I mentioned, that with DAO groups they're sharing governance, ownership, and profit that's been generated by the groups, and they typically adopt a set of values, and that model itself reflects very closely the cooperative model, where it's a set of governance and values that govern, that organize that business, that way of doing business. It's typically member driven or for the member benefit. It's adopts a voluntary and open membership and democratic member control, and those things that we see in the cooperative, very traditional cooperative model, with agricultural cooperatives, utility, and then more recently with multi-stakeholder cooperatives, where you see a variety of membership classes that can be both consumer and workers in the same entity. We're seeing those models closely reflected in how DAOs are choosing to run their entity, run their group or their project as a business activity. So we're seeing quite a bit of those, and again, with a focus on shared governance, ownership, and profit sharing. And Colorado has been a state typically or traditionally very open to cooperatives because their agencies understand the laws that they have adopted. So most states have adopted one or a variety of cooperative statutes that have various levels of flexibility. Colorado's Limited Cooperative Association, the LCA statute, is one of those. And it's not particularly more flexible than the ones adopted in other states, except that the agencies in Colorado have a really strong understanding of that. So it turns out that the governor of Colorado and some of the Colorado agencies that work with the formation of legal entities are also fairly familiar with the crypto world, Web3 and all that. So they are seeing fit to marry those and have, to an extent, vouched for some of the projects that we have put together that combines the cooperative model with a layer of Web3. And that's kind of how we're seeing it. It's maybe a DAO cooperative or a cooperative that's Web3 native, and they're really kind of equivalent at this point to a large extent. Miles mentioned a few of those different types of cooperatives and DAOs, and maybe one that doesn't track as much with the cooperative model is the investment DAOs, because there the goal is really just you're putting money and you're trying to receive more, and that's not how a cooperative works.
Sure.
It's my patronage and the engagement that the members have is what generates profits, and that can be distributed. So as long as there's that member patronage and member interaction, the cooperative model has been working out really well for some of our clients.
Great. Miles, let me move over to you. You've written with a couple of other folks, but I think anyone would agree is the sort of definitive white paper analysis on a look at unincorporated nonprofit associations and how those are can perhaps with a little bit of work fit nicely into a DAO model. It's a sort of thoughtful look at a lot of some of the issues there and some of the tweaks that might be needed. But for folks unfamiliar with unincorporated nonprofit associations, maybe talk about what those are and why you guys felt it might be a nice fit for different DAO structures.
Sure. Yeah, so unincorporated nonprofit associations, they exist in a lot of it's permissible by in a lot of places statute, in some places it's formed under common law, and they just as a whole, the structure allows for a lot of flexibility. It doesn't have a hierarchy corporate structure like you would see with the C Corp or anything like that. It also allows for very permissive kind of membership and roles. And so as a result, you can basically stipulate, exactly how you want your UNA to operate in the governance documents that you adopt at the time that you adopt your DAO. So, governance can be handled on chain, and basically it just provides a very, very permissive framework for being able to have kind of an associated group of people. I think in the context of the paper that we wrote, we were really looking and focusing on protocol and network DAOs, where really the members of that DAO are kind of stewarding a technology. Like if you look at it like it's really a DAO that forms around email, for instance, right? So these protocols need someone to kind of look after their kind of continued development. And, as a result, we think that the UNA is a pretty good structure for that. UNAs also allow for, by statute, particularly in California, Texas, and others, right, do allow for for-profit activity to be undertaken by the DAO or by the UNA. So the nonprofit kind of name in the title of it is actually something that many statutes allow UNAs to kind of engage in. So really, it's kind of just an extremely flexible and permissive framework that doesn't have some of the more complications of kind of the legal structures previously discussed.
Got it. I want to circle back. You mentioned that right at the end, the nonprofit piece. Someone looking at that might think that's not the right fit for our DAO because we do intend to make a profit, have a treasury. Can you maybe talk a little bit more about why that name might be a little bit of a misnomer to people? They nonprofit, they think a charity or something like that.
Yeah, well, so again, by statute, UNAs, technically allow for, like in several jurisdictions, allow for the actual entity to engage in for-profit activity. So anything that a DAO does is really kind of within anything that a protocol or network does is really within that parameter. One of the things that some UNA statutes do restrict is actual distribution of profits from the entity to the actual DAO members. But from our perspective, we don't believe that to be really a significant hindrance to protocol and network DAOs. The reason being that the distribution of profits from a protocol or network DAO to its members creates potential issues under U.S. securities laws. Particularly, there's case law, U.S. Supreme Court case law under Landreth, which indicates that distributions of profits to members could make their interest in that enterprise a share and therefore a security. And so as a result, we think that there is sufficient grounds to avoid kind of distributions of profits through mechanisms that really look like typical stockholder dividends or share buyback programs. And as a result, right, I think that we also are have an opportunity within this industry to really promote stakeholder capitalism, which is a concept that exists in the equities world, but doesn't really work very well because you can't really do that much with shares. With tokens, right, the difference between tokens and equity is very different. And as a result, I think it's not great to treat them as though they are equity by using analogs to the equity world, such as having dividends and share buyback programs. Rather, I think we have an opportunity to design, token systems where token holders can actually deliver value to their, protocols and networks. And as a result of the delivery of that value, be paid for it and really increase the overall kind of efficiency and value creation of the ecosystem. And so as a result of that, I think that the distribution of profits to DAO members via things that look like the equity world are probably not the wisest way to go about designing systems.
Got it. I want to come back to that to the token point in just a moment. Lucy, over to you. So you now heard sort of three different similar, but in some ways very different models. Maybe if you could talk about in the Caymans, the foundation company concept, but also as you're describing it, maybe along the way, sort of compare and contrast to some of the other structures you've seen and how that's similar and different.
Yeah, sure. Thank you very much. And in the Cayman Islands, it's a jurisdiction which has all of the familiar different types of legal structures. So for a long time, it's had companies, it's had limited partnerships, it's had trust structures. But a couple of years ago, a new type of legal entity structure was introduced in the Cayman Islands, which is a foundation company. And although it wasn't introduced specifically or at all with DAOs in mind, I think that it ends up as having been perfectly designed for DAOs. It's basically like a hybrid of a company and a trust. So a foundation company has legal personality, it can enter into contracts, it can protect its assets, hold assets, be a member of sort of trading exchanges, all of those sorts of things. But it also has limited liability. It is managed by its directors, just like a normal company would be. But the key difference is that it doesn't have to have members or shareholders. So just like a DAO, it's not a thing that's owned by its shareholders. It is much more in line with the ethos of a DAO. And all it needs to have is a supervisor in addition to its directors. And the supervisor's role is really to provide a stewardship role. So the supervisor is an individual typically, or there could be an entity, which makes sure that the directors are acting in line with the obligations given to the directors by the DAO, so that the directors will manage the foundation company in line with the requirements of the DAO. It's a very flexible structure. It will have articles of association which get filed, although are not public. And it will also have bylaws, which can be very flexible, so it can really accommodate pretty much any governance structure. And it has proved to be very, very popular. That's one of the reasons that we have seen many of the sort of big household names in this area using this structure for their legal entity. I think one of the other reasons that the jurisdiction has been very popular is because we have virtual asset service providers legislation in place as well. So completely separate from the legal structure, the foundation company. We also have a regulatory structure which provides certainty. I think one issue, I'm a regulatory lawyer by background. It's something that I've been doing for over 20 years in mainstream financial services. And one of the issues that people have found problematic around virtual assets or crypto assets is that there's a lot of regulatory uncertainty about how they're going to be treated, how tokens are going to be treated, and what they're allowed to do with them. The Cayman Islands does provide that certainty because it has legislation in place already. And many token issuances will not necessarily be regulated, but the key point is that they can see where the line is between what will be regulated and what will be unregulated. So that's something that's also helped a lot.
Great, super useful. Matt, I want to come back to something that you touched on. I know one of the things you mentioned was critique over the Wyoming law not being technology agnostic, and I know you addressed that, and very much appreciate the point that legislative making and rulemaking is hard, to say the least. But what's another example, perhaps, of something where now that it's been tested a little bit, that you feel the Wyoming law could be improved, or maybe that other states looking to do what Wyoming has done to foster the growth of DAOs might do a little bit differently than you guys have done?
Yeah, I mean, a couple thoughts on that. One, we've seen a few other states. I think Tennessee has passed a new DAO LLC Act, and we've consulted actually with a number of other states that are looking at it. A couple of the most common things that we hear, and I'm sure every lawyer on this call has had the same conversation 1,000 times as I have, and that is no DAO structure, at least in the LLC context, solves all of the tax and securities issues. If you're going to do a token issuance or something like that, there's so many complexities around that. But that's one of the questions we often get, is what structure can you achieve some type of token issuance? And for that, I mean, a lot of what some of the other speakers are talking about with the foundations and other alternative structures are an interesting way. Back though to some of the improvements or the critiques regarding Wyoming, I think again, sort of the baking in of the digital asset framework is no doubt a limitation. It was an intentional limitation from Wyoming's standpoint, but one that a lot of states I know are talking about and looking at. Wyoming, as an example, we baked into our UCC, we actually appended our UCC to include property definitions surrounding digital assets, which I have to say the Uniform Law Commission was furious about when we first did it, and now they're adopting our definitions. So it just took them a few years to come around. But I think those kinds of things are really what's needed, because where the rubber meets the road in terms of member disputes, at least in our experience, that's kind of been one of the biggest test cases. Doesn't matter if it's a foundation, unincorporated association, or an LLC. What happens, right, when either the governance mechanism doesn't work like it's supposed to, or those common problems of somebody leaving or somebody wanting to come in, and how do you accommodate and how do you deal with that? What are the rights associated? I mean, governance tokens are a common way to deal with that from a technology standpoint, but there's lots of regulatory issues associated with that. So again, Wyoming, we don't have silver bullet answers to all of those, but I think where we're going to see a lot of improvement and iteration is on the integration of some of the regulatory aspects into these entities.
That's great. I want to jump now to the token issue, which in the last couple of answers we've touched on a bit. Just like in the days of ICOs, it seems that people said that, well, it's a utility token, and if I call it a utility token, by definition, it's not a security. We see that, I think, all of us in our practices, that something similar, especially over the past year, as I said, with the proliferation of DAOs and being formed to take on different activities, that, well, it's a governance token, and therefore, by definition, it can't be a security because I said it's a governance token. It's not a security. I wonder, Miles, maybe we'll start with you, because you have a lot of experience, I know, in the token space writ large. Maybe talk through sort of what the risks are, with that approach, but whether there's some sort of, in the current environment, appreciating legislation might come, there might be a different regulatory environment down the line in the future, who knows? But as we sit here today, sort of the risks of having a governance token, and is there a meaningful path forward that companies can look to today?
Yeah, well, I think that as Matt was just saying, I don't think that there's really a silver bullet, right, with respect to token design and kind of avoiding securities laws, right? I think that just calling your token a governance token and having that provide some marginal governance rights, it isn't really sufficient to escape potential application of securities laws, nor is kind of setting up your DAO or utilizing the Cayman Foundation structure, right, really a mechanism that allows you to avoid kind of the application of U.S. securities laws to any issuance of your token. And so I think that I really think that the kind of the discussion around like what the functional utility of the token is, how your securities analysis can really be wholly separate from the DAO. Like ultimately the way that I, for network and protocol DAOs, the way that I look at DAOs is that really, they are a tool set to eliminate kind of the reliance on the managerial efforts of others, which is one of the key prongs in the Howey test, right? And so by having a fully functioning DAO and having a governance token that provides the token holders with the means to govern the DAO, then that is one tool that you basically have to basically trying to achieve this legal decentralization concept that relates to the Howey test in the US. And so I think that and that's kind of where the primary focus has been on throughout the last few years since kind of the digital asset framework was put out by the SEC in April of 2019. I think, as I was saying earlier, right, I think that there are things that you can do with your tokens that can increase the likelihood that they will be deemed to be securities, right? How you how you market them, how you offer them, how you sell them can all increase the likelihood that they're deemed to be tokens. But then also, how your DAO functions and what you do with profits. For instance, if the tokens look like they are shares in a company that and function in the exact same way as that, then there's going to be a greater risk that the SEC deems those to be securities. And I think that from a legislative standpoint, obviously Congress is very focused on this issue now, and I think that it's critical to kind of show that there are many reasons why tokens are not equity and shouldn't be an analog for equity.
Great, that's really, really interesting. Lucy, how about down in the Caymans? Again, sort of similarly, an argument we'll sometimes hear from clients. Well, it's a foundation company under Cayman's law, therefore it's all fine. We have to worry about the token being a security because we've organized under that law in the Caymans. And was hoping you could speak a little bit to that construct and whether that reflects reality of what's out there.
Yeah, sure. The fact that there's a foundation company doesn't mean that the tokens will not be regulated. The foundation company is really just the legal face, as discussed already, that the DAO can use to contract through and provide limited liability. But one still has to look at the nature of the tokens themselves to determine whether or not they're regulated. A couple of points. One is that in the Cayman Islands, we don't have to conduct, from a Cayman Islands perspective, an analysis of whether the token is a security or not, or at least one can, but it will very, very rarely be a security under our securities laws. It would be pretty unusual. It would only be in certain unusual types of derivative that would be the case. We do, however, have virtual assets legislation as discussed. So the real question is whether the token is a virtual asset or not. It might be a virtual service token, which is more like a utility token, but it will only fall within that category if it can't be transferred. So from a Cayman Islands perspective, most governance tokens will be regarded as virtual assets, and they may or may not fall within scope of the regulation, depending on what the activity is that one is undertaking in relation to those virtual assets. So the virtual assets themselves won't be regulated, but a person, legal or individual, who's carrying out activities in relation to that token could be regulated depending on what they're doing. In relation to just the issue or distribution of tokens, which are virtual assets, so just saying for the sake of argument that you've got a governance token that's regarded as a virtual asset, the issue may or may not be regulated depending on a few factors, but a lot of the cases that we deal with, in the majority of them, they're probably not regulated. There is an exemption for private issuances. Also distributions which are not sales wouldn't fall within scope of regulation. So it's a different analysis. So that's the Cayman Islands perspective. But as Miles mentioned, not just in this realm of tokens, but in terms of any type of regulation, one has to look not only at the jurisdiction of the issuer or of the where the tokens are being issued from, but also in the jurisdiction where they're being offered. And there will be a separate analysis in the US and in any other jurisdiction where the tokens are being offered. So just as in the case of traditional securities, it's also true of tokens that you have to really look at the bigger picture and not just the jurisdiction in which the tokens are being issued.
Sure, that's great, super interesting. Thanks, Lucy. Jack, let's switch gears a little bit, and maybe if you could talk about a use case you have seen where a DAO has been operating successfully, and I guess you could define success a lot of different ways, but has been sort of working. I guess what I would mean by success is less so maybe in terms of revenue, but success more so in terms of the organizational management and structure and governance working out. Maybe pick an example of one DAO you've seen that fits in sort of how it organized itself.
Yeah, so one that I'm quite a fan of is Opolis and the Employment Commons. And so the way it works is if one service-wise, it provides access to benefits to workers. So folks working in a variety of DAOs or kind of operating almost as contractors in a variety of DAOs that have no employment or working relationship that covers them for benefits, they can join the Employment Commons that negotiates and operates as a purchasing cooperative. So this entity negotiates benefits for the members, and the members can provide services elsewhere and then be covered for insurance and other kind of worker-related benefits through being part of this DAO. So they work in close relationship, Opolis and the Employment Commons, and Opolis kind of provides management services to the Employment Commons that runs as a DAO, and it's kind of validated by its members. So that's a model that's been fairly successful. They've been in existence since 2019. It was our first DAO cooperative to form, and they actually collaborate closely with folks at ETH Denver. So that's one that I like seeing quite a bit, and they're providing a very needed service. I think I'll just plug into, I guess, the follow-up. That's, I think, one of the things that are gonna come up after this year or so of figuring out legal entity is employment relationship in between the DAOs and its members, participants, contributors, and all that. So I think when an organization like DAO One starts providing some of the services that are lacking, but maybe also some clarity or provide some framework for clarity in those relationships that will maybe that are a can of worms and will become possibly a icky issue to deal with the next couple of years.
Sure, that's great. We've covered a lot of the questions that are coming in through the comments along the way, and I've tried to steer some of the questions to that. One we didn't touch on, which I think is interesting, and maybe Matt, swing it back to you and looking at it from Wyoming law, and then we'll touch on a couple of the other structures, and maybe that'll bring us to the end of our time, which is, so I'm a DAO member. Assume I'm not one of the founding members. I didn't get it off the ground, but I'm a DAO member, whatever that might mean in the different constructs we'll talk about. Does that impose obligations on me that might be different from some other organizational situation I might join? And if so, what does that mean? In other words, could I just sort of be along for the ride and vote on things, or do I have additional legal obligations that attach to being a DAO member? And Matt, maybe if you could take it from a Wyoming law perspective as to what that would mean to just your sort of run-of-the-mill DAO member.
Yeah, so my answer is going to be imprecise because I think the law is incredibly flexible in that respect. And I'll give you a couple of examples. We had a DAO that we formed last year, and the DAO structure that they wanted to achieve was a few initial members, which is very common to most DAO projects, right? You have a core team of folks that want to launch this thing, and they were willing to put their name on it. But what they wanted to do was utilizing the Wyoming Digital Asset Definitional Structure and the DAO Act. They wanted to create tokens that would allow them to delegate voting and control, certain aspects of voting and control, to the token holders. So in that context, it was sort of a defined project that, hey, we're gonna have the DAO, we're gonna be this limited liability entity. We are gonna use this token structure to delegate certain functionality and certain voting rights to those. We used our operating agreement and sort of the legal framework that was available to define them as non-members in that case, which we think our law is flexible enough to permit. So you can have participants in the entity that aren't actually legal members. So that's just one example of kind of the I don't know, some of the creativity that people have brought to us to use. And you know, we have a brand new chancery court here in Wyoming that's super fast. So we're hoping to get, I shouldn't say we're hoping, one of these days, whether we like it or not, we're going to get some disputes in front of that chancery court interpreting some of these member rights. But that's going to be interesting. But that's just, I could give a million examples.
Sure.
But I think there's tremendous flexibility to delegate even to non-human actors.
Got it. Wait, let's touch on the last part for a second. We had a question about that as well. So what do you mean by non-human actor?
Well, I think one of the aspects of a DAO, right, is to some extent automating features of governance or features of transaction execution. And so the DAO, I mean, the Wyoming law references algorithmic managed. We didn't intend to have two different types of DAO LLCs. In fact, that language has since been cleaned up by our legislature, but the law expressly permits for certain functionality of the entity to be delegated to non-human, right, protocols or algorithms or whatever the case may be. And so I think that that's within the realm of possibility as well.
Interesting. Miles, how about in the unincorporated nonprofit association you talked about, if I'm an individual member of that, did I take on certain responsibilities, fiduciary loyalty, whatever it might be, that I might not have otherwise realized I was signing up for?
No, I mean, I think that the UNA statutes do provide limitations on liability with respect to individual members. So I think that ultimately, you're not kind of taking on the potential, liabilities of the group. Now, whether or not you can be sued by someone, obviously you still can be, right? But I think that ultimately we'll see that the limitation of liability on those structures are withheld. I think that, one of the other things that's on the horizon here that's also going to weigh pretty heavily into, DAO legal structures, right, is the CTA, the Corporate Transparency Act, which applies to, co-ops and to LLCs, and, really will kind of put limitations in place as to the ability for structures to use or to maintain the anonymity of their members. At the moment, it doesn't apply to the UNA structures. And so that's kind of one of the key reasons why for bigger, protocol and network DAOs where anonymity is obviously going to be, a necessary trait, that the UNA structure is kind of the best suited for it.
Got it. Let's end up with just a couple minutes left, a sort of quick lightning round, sort of go around to the different panelists. And Lucy, I'll start with you. If the question is, sort of 5 years from now, do you see DAOs as something that's sort of a little bit of a fad that's going to fade, or do you see that DAOs as having and same question for everybody, as having a pretty solid piece or place within sort of different corporate structures, the way people talk about LLCs very naturally today?
Mm-hmm. I think the DAO is here to stay. I do think that at the moment, the way it looks is that it will need some form of legal structure through which to operate, because I don't think the rest of the world is going to change. The system that we have at the moment will need to be a legal structure for the DAO to operate through.
Great. Jackie, how about you?
I think that we are going to move towards seeing the DAO term as a way of doing business more so than anything. So a governance layer that we add to a variety of other legal businesses and entities. So I think it's going to look like a little bit of a sociocracy applied to startups. and just shared decision making with stakeholders. So I think it's just going to anchor the stakeholder model with that way of managing decision making.
Got it. Matt, how about you?
Yeah, I actually really like the way Jackie just phrased that. I tend to agree. I think it's going to become a sort of a model for the way that companies want to run themselves and organize, and that over time we're going to see some different structures, just like we have, you know, a variety of different business entity structures available now that you can fit that model within depending on the use case.
Great. And Miles, I'll give you the last word.
Yeah, no, I agree. I mean, I think that that's the right kind of way of framing it. I think that, look, at the end of the day, there are a lot of different types of businesses in the world. A lot of them are not going to be able to work as decentralized businesses, and where that's the case and where that continues to be the case, a DAO probably isn't a good framework for them to utilize. But where you can decentralize decision making and get rid of hierarchies, I think that this represents a really promising avenue for people to pursue.
Great. All right. I think that brings us to the, I would say the top of the hour, but really 10 after the hour. So thanks very much to the panelists. That was a great discussion, really good insights, and hopefully we introduce some topics like the Unincorporated Nonprofit Association and what's going on in the Caymans, and the cooperative law structure that people might not have been as familiar with.